All right, welcome back for everybody online, and we are going to take our next panel now. It's a new panel called Masterclass. It's the first of three today. Managing a true corporate crisis or major internal investigation. This is going to be a great panel. But real quick before, it looks like we have a lot of questions today. This panel is going to run until 9:50. So if you have any questions, please hold them until 9:45. I'll grab a mic so that you can be heard and the audience online can hear as well. All right, let me quickly introduce our panel today. Let me start with Bill Baker. Bill's a partner in the Washington, D.C. office of Latham and Watkins. He is a leader in helping firms of all kinds in SEC and other enforcement proceedings. Prior to joining Latham, Bill was Associate Director of the SEC's Division of Enforcement for 15 years. Also pleased to introduce Mark Cave, Associate Director in the SEC's Division of Enforcement. Mark joined the SEC in 2010 as a staff attorney, and he served as an Assistant Director and as a Senior Counsel to the Director of Enforcement. Welcome, Mark. Thank you. Phil Khinda. Welcome, Phil, partner at Cadwalader, also a veteran of the Enforcement Division. He's one of the top advisors to public companies and corporate boards when it comes to matters such as internal investigations. He's led huge investigations such as the CalPERS special review that dealt with pay-to-play and public corruption. Always great to have Phil here. Welcome, Phil. Very pleased to have Steve Peikin here today. Steve's a partner at Sullivan and Cromwell in New York, where he leads the firm's securities and commodities investigations and enforcement practice. Of course, from 2017 to 2020, Steve was co-director of the Division of Enforcement, a past keynote speaker here on more than one occasion. Thank you for coming, Steve. Steve also was an AUSA for 8 years in the Southern District of New York, including as chief of the Securities and Commodities Fraud Task Force. And finally, our moderator, Hashemi. Kaz is the chair of the litigation department at Wilson Sonsini. He's represented companies and boards in more than 100 SEC government and internal investigations during his career. He's also a veteran of the Enforcement Division. He's now been at Wilson Sonsini for over 15 years. He's built a global and multifaceted SEC enforcement practice. Kaz?
Thanks, Bruce. And as you mentioned, this panel is about how to manage sensitive internal investigations throughout its life cycle from beginning to end. With any major crisis, usually brings an internal investigation. Usually a committee of the board is tasked with reviewing the issue and hires counsel. Usually brings public attention and then an SEC investigation. So it's a lot of moving parts, and interacting with the SEC is a big part of it. So let's start there, Mark. In the last year, we've seen settled SEC actions where cooperation or lack of cooperation is figured prominently. In the EY case, the SEC came down on EY. In the Cronus case, it went well for Cronus. Maybe you can tell us a little bit about those cases and what you look for in the interaction and cooperation.
Sure, thank you. And just before I begin, obviously, the views I express today are my own and don't necessarily reflect those of the commission or its staff. But sort of, in the internal investigation, right, that jumping off point is what point do you self-report and how do you self-report? The objective there, or one of the objectives is sort of, I understand it, is that the client is trying to get some type of cooperation credit at the end of the SEC's investigation. The primary way that we look at that is obviously through the C-board factors, right? So that's self-reporting, cooperation with the staff's investigation, remediation, and then the corporate culture of self-policing. That's sort of the primary lens. And there's obviously a lot that goes into each of those factors and how we consider them. And you do see that in play in both the E&Y matter and in the Cronus matter. And if you haven't read the E&Y order, I actually commend it to you because it's an order that really does go through in some detail where the cooperation defects were. And what you saw in that matter, and that's detailed in the order, is commission findings that at the time that E&Y was engaging with the commission staff, it was aware of information pertinent to the staff's inquiry that it failed to share. And then not only failed to share, but also failed to share for a period of up to 9 months. And even at that point, didn't share directly with the SEC, but instead shared the information with the PCAOB. So ultimately, and The overlay there is a fact pattern where the conduct is egregious, right? I mean, that case involves cheating on the ethics component of the CPA exam by a significant number of EY auditors. And so you have egregious conduct by a gatekeeper entity, and then a failure to disclose that in a timely manner in the face of an express SEC inquiry. And so under those circumstances, right, it's not hard to see how the company failed to qualify for cooperation credit. Now, you pair that on the other side with Kronos. Kronos is a Canadian cannabis company, and the misconduct alleged in that or charged in that case is not insignificant, right? It was a multi-quarter financial fraud that ultimately resulted in 10B charges. But there, when you look at the type of cooperation credit that the company got, and what's detailed in the order, is very significant cooperation that really did begin with, and this is all laid out in the order, a self-policing culture within the firm that identified the misconduct early, and a prompt remediation of that misconduct, prompt and then continuous self-reporting. So Kronos didn't just self-report the initial misconduct. They reported early, before they necessarily had a complete handle on what the full scope of the misconduct was. And then they continued to report. And so as the SEC staff was conducting its investigation, Kronos Counsel and Kronos were taking active steps to keep the staff abreast of new developments. And so those two cases, E&Y and Kronos, really do, I think, show kind of what the polls are to some extent of sort of how things can go wrong with respect to cooperation and getting cooperation credit, and then how you can do things right, even in the face of significant misconduct, as we saw in Kronos, because Kronos, again, it's multiple quarters of 10B misconduct, and look, they did get a zero penalty, but they also there was also an IC in that case, and so looking at the total package of relief, it's important to note that even though we went to zero on the penalty, we are still looking at the prophylactic relief that we needed in order to ensure that investors are protected going forward.
Steve, how about giving your perspective on cooperation and interaction with the staff during a major internal investigation?
People have been sitting on this panel since, my ancestors' time, sort of whining that the Enforcement Division hasn't been consistent or transparent about how it thinks about cooperation. And I think from the Enforcement Division's perspective, it's a bit of a difficult puzzle to solve because, first of all, you could be a great cooperator and really help the staff, but other factors could outweigh the credit you get for cooperation and don't result in no penalty or reduced charges. There could be, significant investor harm, egregious conduct, et cetera. And there aren't benchmarks against which to measure the result, right? So there isn't like a set of sentencing guidelines where everyone knows the penalty would have been this, but for the cooperation, and it's there. And so I think it's been difficult, and one of the things when I sat in the seat, it's difficult to try to convey enough information to the industry and to the bar so that the bar knows kind of what am I supposed to do. And I think you have to find vehicles like Mark's Kronos case where you can spell out what exactly worked and what resulted in cooperation credit. I think that, from the defense perspective, the challenge, cooperation credit isn't like a gold star because you have a nice heart, right? I mean, it's because you helped the staff advance its investigation in an efficient and resource conserving manner. And I think when you go in to pitch cooperation credit, you need to explain to the staff in a compelling way, here's what I did, and here's where you would be if I didn't do those things. Sometimes that's easier to do than others, but to me, that's the way you have to get cooperation credit, by showing this would have been a different set of facts if we hadn't done these things. You'd be off waiting for the MMOU responses, or, these witnesses wouldn't have come and you'd have had to fly to, Germany or something like that. And so, that's the task.
Mark mentioned self-reporting even when you don't know the full extent of everything. What in the case, Steve, where it's non-public, an issue surfaces, you don't know where it's going to land yet, you start the investigation on behalf of an audit and special committee. How do you go through the analysis of when to report it when you actually don't know if there's an issue or not?
Yeah, I think that's really it's a very difficult situation. I think the idea, to the extent the staff's expectation is, you got a hint of a problem and you're starting to dig in to see if you've got a problem, we should call up and tell you about that. That's not realistic. That's not going to happen. Nobody does that. I think once you realize that you've got a real problem and you're going to be telling your auditors and other stakeholders, then that's the sort of inflection point when you think about, should I be calling to report? Because this is a real thing, even if I don't know the full scope of it.
Phil, why don't you jump in here with some thoughts on what we've been talking about?
I agree. I think, to me, it all turns on the perceived materiality of what you've got in front of you. And so once we realize we've got to go out to others, that's the point. Would I prefer to not tell the story until it has a happy ending? Sure. That's not the way the real world works.
Do you have any cases with happy endings?
Every one of them. I will say this on this point. Whether it's a self-report or an internal investigation, I've said this in different panels, I believe it even more firmly now, it is imperative to think of the very end from the very beginning. So if I'm company counsel, it means that keeping the bankers happy, the stakeholders happy, our investors happy, the government happy. But if I'm doing the internal investigation, it's less about outcome and it's more about process. I need to conduct a full and fair investigation that I can demonstrate, perhaps years from now in follow-on litigation, that it stands the test of time, that we didn't pull our punches, but we also didn't rush to judgment. And that, to my mind, is the single most important thing. It's a lot of client management, because they'll say, well, what's the government going to make us do? And my answer to boards who say that is, the government could get busy on something else tomorrow. You are on notice now. You have to jump into action. Let's think about the end at the beginning and let that guide us throughout.
Bill, let's step back. Let's say you're outside counsel to a high-profile company. The general counsel calls you and says that an allegation came up a few weeks ago against some executives on an accounting issue, and they've looked into it. There's no merit to it, and nothing else needs to be done. And they seek your advice on what, if anything else, they should do. How do you talk that general counsel through the potential pitfalls?
Well, if the general counsel is so confident, they really don't need my advice, right? They've solved the problem, and there's really no reason to engage me to do any more work. I think, look, these are all scalable, right? You'll want to know more. How did this come to his attention? Did the auditors bring it to his attention? So there's the possibility of a Section 10A report. Did it come up through a whistleblower? We just had a great panel on whistleblowers. So that there's a distinct possibility that the SEC already knows about the matter. And then trying to understand what in fact work was done. If it came up through an internal audit, it was an issue that an internal audit discovered. And there's been a thorough review that the general counsel may be right, that they don't need to do a lot of additional work. You also want to think about what are the consequences, internally if he gets it wrong, and trying to walk him through that. And the personal exposure that in this world, the name of the case is escaping me, Mark, but the case you guys did against Synchros, I think, where the general counsel was involved. They have personal liability, and I think that really helps an officer, whether it's a general counsel or otherwise, to focus in a way they might not if they see that their neck is on the line. And it's all going to flow from that.
Steve, say you're engaged by an audit committee to look into potential accounting issues related to financial statements. First, how do you help the audit committee or special committee scope the issue? And second, how do you deal with the auditors, both from the maybe underlying witnesses to the events and obviously the privilege issues that are around with the auditors?
Yeah, I think that, you have to balance two things. One is there's always intense time pressure to get to answers. But you have, as Phil said, you have to do an investigation that has sufficient thoroughness and integrity that it will stand the test of time and stand up to the measurements that are going to be made of it, right? And the auditors are obviously, a key measuring stick. My approach has always been, to be as completely transparent as it possibly can with the auditors, get them involved early. If the audit team needs, to consult with the national office, encourage them to do that early on. Be transparent with them. Here's the search terms I'm going to use. Here's the witnesses I'm going to do. This is my investigative plan. This is my path. Because what you don't want to do is do a bunch of work and then have them say at the end, we're not satisfied. You didn't dig deep enough. And look, I think the audit firms, some of them behave better than others in the face of these. I've had really, really good, constructive, positive working relations with some audit firms, even when there are significant issues that maybe the engagement team, fell down on in spotting. And then there have been other experiences where they seem to go into, tortoise mode, crawl in the shell, and you indicate they're never going to sign off on the financials. So I've had both experiences, but I think that trying to be economical with auditors in the face of a potential Tenay investigation is not a recipe for success.
Two wild cards, Steve, I think are, one is you have no control and no visibility to, which is the national office, and you mentioned bringing the national office in. The other wild card, I think, is the forensic team that auditors inevitably put into place, and that can have I think, at least in my experience, a very significant effect on how the kind of relationship you're going to have with the engagement team. And if the forensic team is experienced, they've been through this before, even if they're in a defensive mode, the conversations I think are going to go a lot more smoothly.
I totally agree.
How do you deal with if they're a key witness to the underlying events and potentially interviewing them during your internal investigation?
I don't know. I've never been allowed to do that.
Yeah,
So, I don't know.
You're more persuasive than I am if you've ever gotten to interview auditors in an internal investigation.
Yeah, it creates an awkward scenario when you're reporting out to them.
You can't put a client in a situation where they're potentially adverse to their auditor, right? And so often you have to investigate around that. So sometimes, we've been allowed to inspect documents, but I don't think I've never sat across the table from, the engagement team to interview them in an investigation.
We've had large meetings, but, where we talk kind of hypothetically, were there any concerns, this and that, but you're right, you can't, it's in many ways, in my experience, like dealing with the government, which is to say, I undertake, again, there's a grace, there's a diplomacy to this, but it all comes back to command. If I'm doing this work on behalf of the committee, I will very quickly know more than everybody else, perhaps everybody else put together in the early going. But what I can offer them, I would offer to Mark, I can offer to the auditor is, I'm not going to surprise you. And I'm going to keep you as fully in the loop as I can, bearing in mind I have to keep privilege issues. And so with the auditor, there's that dance between, I don't want to create adversity. I also don't want to create some appearance of a joint defense, but I want to keep them happy. And so the key point is to find a way, as I would say to Mark, if there's an important piece of information, I'll find a way to get it to you. And then we do it that way. And it's gone, to the point where they feel like they've got to pull it out of us, but that's never the case. I had one matter where the state AG wanted to write us a common interest letter that I was concerned would make us state actors. And so we said, thanks, but let's just talk. It's a balance, but it's manageable.
And Phil, I know you wanted to talk a little bit about the collateral consequences sometimes internal investigations bring in terms of lines of credit and private litigation.
Yeah, I think when you're running the internal investigation, it's more of this ivory tower role, the search for the truth and all of that. When you're company counsel, and so let's make the example harder, where I'm running an internal investigation on behalf of management because the senior executives are not implicated, right? That would change. Of course, if they are, then I've got to put it somewhere else. Then I've got to balance a lot of things. I've got the bankers very quickly saying, are any of the loan covenants off? Because then the revolving credit line's gone, and you better have your bankruptcy filing ready right away. I've got, maybe if it's a fund, I've got LPs I've got to talk to. I've got kind of most favored nations I've got to coordinate. Am I telling everybody the same thing? I got to make sure Mark's not left out. It's that balance that I want to share the information, but I don't want to do it in a way that's alarmist such that, plaintiff's law firm X, Y, and Z are investigating whether, right, that's a, pure money grab, but I've got to be mindful of that. And so it's understanding all those constituencies. So as I say to folks in the government, if I seem tired at the first meeting, it's because I've probably already met with the board several times and the bankers and dealt with the major creditors and investors. And perhaps your colleagues at the Department of Justice and the AG's office, though I'll keep you apprised. And then, of course, the auditors, which that's the first marriage that needs to be saved, in my opinion, is if that stays intact, or put another way, if that blows up, it becomes a mess of a much greater magnitude.
Right. Switching topics a little bit, Mark, the chair emphasized the commission's focus on record keeping of off-channel communications, text messages, WhatsApp, in a recent speech, and I came on the heels of that big settled action with regulated entities. Can you give some perspective on the staff's view on that, and especially in the context of internal investigations where they're gathering and collecting documents?
Yeah, I think in those cases, right, you saw regulated entities, broker-dealers that have very clear record-keeping obligations under the federal securities laws that had failed to preserve off-channel communications often for an extended period of time. There's really no ambiguity under the relevant statutory provisions that there is an obligation to retain those things. And so this is a sort of just a failure to really stay up with the times, right? Were compliance departments within these financial institutions surprised that bankers and analysts were using WhatsApp and other off-channel communications? It seems unlikely, right? And so in terms of what that means for investigations, I think you have to think, one, what are your statutory obligations, right? And so whether you're a regulated entity or you're a public issuer that may have other industry-specific record-keeping obligations, you have to be mindful of that, I think, whether that's, you're a broker-dealer, an investment advisor, an auditor. There are statutory requirements that you either maintain all communications or certain categories of communications. And I think what we know clearly now, if we didn't before, is that simply preserving the email is not sufficient, because email is simply one form of communication now. And I think, 5 years ago, it may have been the predominant form, but increasingly in our investigations, and I think increasingly in everyone's own personal experience, email is sort of fading as a dominant form of communication. Instead, it's one of many forms of communication that people use routinely. And so obviously there are retention obligations that flow from that. So in an internal investigation, you may be thinking about your statutory requirements, but you should also obviously be thinking about your litigation hold requirements and your document preservation requirements, and whether your internal investigation is actually scoped appropriately to ensure that you are identifying the key documents. And so simply going to the email server, right, is not necessarily sufficient at this point. Now, one of the things that we do see frequently is what I consider to be sort of an artificial boundary that issuers draw in their internal investigations between documents that they say they have possession, custody, or control of. I've got possession, custody, and control of the email server, and so therefore, right, I'm searching the email server. And it can be months before we learn that the primary form of communication is on people's personal devices. Well, and what steps were taken to secure the information on those personal devices? No steps were taken to secure those information. Well, okay, now can I go get that phone? Well, you can, but the two executives, actually, they just got new phones, right? And so all of those communications are gone. Well, whose failure is that? And where does that failure lie, and what are the consequences for that failure? The consequences can be significant in an investigation. They can significantly imperil an investigation. But it starts with a pretty easy thing to fix at the outset of the investigation. Go get all of the communications, make sure they're secured, make sure you're searching them in a way that makes sense and is proportional in light of how people actually communicate.
So, look, I think this focus on personal devices, which is completely understandable, right? There can be really valuable information contained on people's personal devices. But I think it's the most significant change in the way investigations, government and internal investigations, are going to be done, at least in my memory. Every case now is a personal device investigation. Every staff attorney wants to know, what's on personal devices. And I think the thing that the government needs to understand is, if you say to the average employee, not a registrant, but somebody, give me your phone, I want to image it. Nobody's going to say that. I mean, that's like, let me go into your house and rummage through your drawers, right? It's your whole life on the phone. No company.
What do you have to hide, Steve?
I don't have anything to hide, but my life is extremely boring, I can assure you. People aren't going to give that up. So what do we do in the text messaging cases? We went through this elaborate, protocol where we had counsel for the individuals, a vendor engaged by counsel would make an image, we would give search terms, we would ask them to isolate the business communications and then share them back to us. I mean, that's a very difficult, cumbersome, expensive and time-consuming process. And I think if the SEC staff thinks in every case, every company is going to go just take an image of every employee's device, I mean, every case will be, you better bet a longer statute of limitations, because every investigation is going to take 10 years. And so I just don't think it is, I understand the desire, because there could be gold in those WhatsApp communications, but it's not an easy problem to solve.
And in more than one investigation, I've had the staff suggest that you shouldn't tell people, you make them come to the room and then surrender their device without any pre-notification. It's just no, public companies are not the equivalent of an FBI agent armed with a search warrant. And can't do that. I agree 100% with what Steve just said.
And I have had people, seemingly, responsible, adults, have violent reactions to the idea of, like, you're not imaging my phone. I quit before you take my phone out of my hands.
Rhymes with Tom Brady. To me, there's a balance between two things. If I'm doing the internal investigation, I, like Mark, I just want the truth. I want everything. And what I think the government's been really good about is
Come in.
in these messaging cases, it's not just that there were communications or even relevant communications, but problematic relevant communications. And that's when they land on people. And so I get that. And I want to get the information. But if I'm company counsel, my duty is to protect the institution. How do I do that? When I do the lockdown, I include everything. Why? Because if employee X has a campfire, gets rid of the phone, that's on them, not on us. And we can say to the good folks at the SEC and elsewhere, yeah, we captured this stuff, or we hope to. We told them, they were on notice, that we expected them to do this. But Steve's right. The government has to also understand it's not as easy as having people come to a conference room and hand over the phones. There's a whole protocol you put in place where you get them their own lawyer, you get the vendor, you do the review, and even an internal investigation, and even if I'm company counsel, I, to some extent, have to rely on the kindness of strangers. I can always just say, look, I can't get it out of them. If you can get better results, go get them. And we've done that in the past, where we've just said, look, we've got these people, they're intransigent. We think they've got relevant information. We've told them we're going to draw whatever adverse inference we want from the fact that they're not giving this to us. But the alternative is they're going to hear, from somebody who's got subpoena power.
But I think one of the things here that I think bears emphasis is that we want to avoid a surprise, right? If you really do have a very complex, time-consuming, expensive process, and you're not running it for some reason because you think it's not proportionate, you think that it's unlikely to yield responsive information, then transparency is what's key, right? We know that this set of documents exists. We know that it may contain responsive information. We aren't searching it for the following reasons, right? What you definitely don't want to do is let those documents be deleted, destroyed, lost, and then have the staff find out when it's too late to remediate that the documents have disappeared.
Your point is tell us, and then we'll, your point is tell us and we'll subpoena it. if you can't get it, and if you're following what Steve was saying, is tell us, and then we may be able to take steps to secure that phone.
And there are, look, I think one of the things that we are having to do more frequently now is subpoena individuals directly for information on their personal devices, because increasingly we are getting the argument from corporate issuers that what's on the personal device, even if it's business communications, isn't necessarily something that the issuer has custody or control of. And so we are having to often take additional investigative steps. And I think there are arguments on both sides of that. But we just see too many cases where, it's not the sort of reasoned, thoughtful analysis that Steve and Phil walked through. It's a failure to ensure that information is secured, that creates significant issues or creates a surprise that I think will create problems with the staff. And look, these are new problems, right? And they are expensive problems. But document collection has always been difficult and time-consuming and expensive. We've all, anyone who's practiced for any period of time remembers collecting documents from a client that had just stacks of paper in their offices, right? Huge stacks, and an associate had to go in and sort those documents and copy the documents and figure out what was and wasn't relevant. That was time-consuming, it was labor-intensive, it was expensive, it required vendors, right? All of the things that Steve is saying about what's required with these electronic devices, those aren't new, right? Those have always been there, and it's always been a problem and a challenge in collecting and preserving documents. And so, look, the thing to do, let us know what the issue is, let us know what steps you're taking, and I think we can generally work out some kind of understanding or take steps that we need to take to protect ourselves.
I think the new wrinkle in this is to have basically a repository that is a mixture of people's most intimate personal details of their intimate personal life and business communications in the same box.
Right.
So you wouldn't send an associate into somebody's bedroom to look through their underwear drawer, right?
Thanks for that imagery.
Well, but if they kept all of the draft prospectus supplements in the underwear drawer, you would. So
yeah. So I think look, I'm not unsympathetic to the idea that these can be, important documents. If they're business documents, business communications, they can be really important. They need to be preserved, and they need, in a reasonable manner to be collected and reviewed and produced. I'm not unsympathetic to that. I'm not saying, oh, I happen to keep it on my phone, therefore it's insulated from the review. But I think that it's just a harder problem than I think, maybe people appreciate.
yeah, and look, I think, we often get arguments about why documents weren't collected or why documents aren't being produced that, I think in a civil litigation, if you were standing up in front of a judge and defending that in a discovery dispute, wouldn't be credible for a court. And if you're using those arguments with us, you should also expect that we're not going to find them to be credible.
That's a fair point. Bill, Steve brought up individuals. Let's now pretend you represent an individual who is a senior executive. Allegation has been made. There's active SEC and criminal investigations, perhaps. How does the panel, all of you, address that situation with the executive when you don't know exactly? You're just brought in. The special committee or audit committee's counsel wants to interview your client. How do you navigate that?
Yeah, I think the reality is that, when I find myself in that situation, oftentimes the choices are really limited. Most, sort of senior executives of, institutions that you're kind of imagining aren't at liberty to say, I'm not interested in talking to Bill. So these are, you often have to, submit to being interviewed with incomplete documents, early stage, under time pressure. But the reality is that people don't have unlimited choice if they want to remain part of an institution.
I think you have to kind of embrace To my mind, if I represented an executive in that situation, look, embrace the idea that you're going to be an information source. And the more time we spend talking to Bill and telling him why, okay, this is our part of it, but not this, the more time he can spend talking to Mark, and maybe it's the less time I have to spend talking to Mark. And so to me, that's the way you, I don't want to say flip the script, but in many respects, you arm the other people who by necessity will be in regular contact with Bill to carry your message so that you don't have to do it. We can become more and more, if you do it right, kind of fringe players in the story.
Bill, what if it's a former executive?
Yeah, if it's a former, that's among the most challenging situations. I mean, it's going to depend. Is it a senior officer who's entitled to advancement and indemnification? Are you going to have some opportunity for advocacy so that you can make sure that you're getting adequate information before the client goes in, and to get an understanding of what the issues are? Hopefully you're retained before the initial interview so that you can at least take some steps towards preparation. Frequently what happens is somebody goes in and is interviewed, and then you get the call, and you're left with at least the initial record. I think, candidly, a lot of investigating counsel, I think, make a mistake in the interests of moving quickly. They try and avoid having other lawyers get involved. That can have the possibility to create significant issues down the road if the interviews are just wrong because people misunderstand the questions, because people misunderstand the documents, and it's not in anybody's interest to have a record where people are just wrong about what happened.
Kaz, there's an important point we should add in here, which is this idea that I'm a big fan of, which is, investigative or special committee advocacy. And so whether I have an individual or even the company, cooperating with the government is great, but also encumbering the investigator with, in a sense, the obligation to say, we learned this from them. We learned this because they brought it to us quickly. They were as open with us as they could be. Mm-hmm. And again, you almost make the investigative piece of this certain. Again, if you do it right and if you've got the right facts, but it's something that I think doesn't get done enough.
Yeah, so I think one of the things when I represent companies doing investigations, I'm not trying to relive my past days as an assistant U.S. attorney where I have to, conduct interviews, act like a jerk, and ambush people. I will frequently. Is that what you do? Yes. The jerk thing maybe a little bit. No, but I will say to counsel for the individual, here's the topics we want to cover. Here's the documents we want to show. I mean, if you can responsibly do that without compromising your investigation. I want them to be prepared. Unprepared statements, I think there are people in law enforcement who think the best thing I can do is catch somebody unawares. People tend to say stupid things, they lie, they say things that are wrong. If you're actually conducting an investigation, you're trying to get to the truth, right? And so you're not trying to trip people up. And so I think this sort of, there doesn't need to be, obviously the investigation can't be, a sham, right? But you can have a dialogue and openness with, lawyers who are representing individuals that you need to gather information.
There's plenty of opportunity to corner people on the facts. You don't have to do it on the staging. I agree.
Mark, any view on this topic about the interaction between an audit committee or special committees counsel and a former executive? And Bill's willing to bring his executive in as long as some information is shared and he could adequately prepare his clients. Does the staff any views on that topic?
In terms of sort of how those things are managed internally, I think that's something where, I personally try to stay out of that in terms of, look, we want, to Steve's point, it's important that the investigation not be a sham, right? So, so there are certain guardrails there, but I think my basic position on most of these things is that people are entitled to their own counsel. And a lot of those internal deliberations about who's represented, how they're represented, are things that we tend to stay out of. I don't know if that's responsive.
No, it's totally responsive. What about witness readouts? Is that a big part of cooperation from you, getting witness? We're talking about interviews, getting witness downloads, and then I'd like to talk to the panel about the privilege associated with that.
Yeah, sure. So, look, You can't sort of answer that question without touching on the privilege issue, right? And for a number of years now, we've been talking about the cases where, I think it's SEC v. Herrera, where there was a finding that the work product protection was waived when the staff was given readouts from these witness statements. I think, look, we are interested in knowing what witnesses said because we are interested in the underlying facts, right? I think that's pretty clear from, the enforcement manual, right? What we seek in these contexts is the underlying facts, and how you choose to give us those facts, right? There are a lot of different ways to get there. Sometimes the easiest way to do it is to simply give a witness readout, but that's not necessarily the most efficient way of getting there. And so sometimes it just requires a little bit more thought by defense counsel about how to convey the underlying information without doing a readout that may compromise work product protection. So we are interested in the facts. We are interested in getting the facts in a timely manner, but we also understand the issues with privilege or work product waiver and can generally find a solution to that.
I just think readouts are lazy and irresponsible, frankly. I would rather have a conversation with Mark where I say, here's where we are, here's what we believe, here's why we believe it to date from this paper, that paper, talking to John, talking to Jane, and then have it kind of thematically go that way. It's both, I think, more constructive in terms of the discussion, and I'd be doing the client a disservice if I was, allowing plaintiffs someday the ability to break through everything. And then Mark's got to be worried that he's getting surprised because he didn't see that, and it's a mess.
Yeah.
Kaz, can we take a couple quick questions?
Oh, yeah, sure. Well, go ahead.
I was just going to say, the thing that you have to balance against that is giving the government a summarized or homogenized view. You may leave something out because you didn't think it's important, and guess what? I find the government doesn't have a very good sense of humor about that. And so the readout is self-protective in a way. I
sometimes they request it. Can we have a readout, a download? Questions?
Speaking of lack of sense of humor, let's go back to the auditors and privilege. Clearly, the auditors have an expectation of receiving as much information as possible to inform their decisions with respect to the audit. I mean, I realize we're short on time, but any quick thoughts on preserving the privilege with respect to communications with the auditors, yet doing enough to satisfy the auditors to enable them to go forward?
Bill?
Yeah, I think the case law on sharing information with auditors is way better than it is in preserving work product, is way better than it is with respect to sharing with the government. And the auditors hold the key to assuming there are accounting issues or management integrity issues involved in the investigation, the auditors hold the keys to the kingdom, and you're not going to have very many arguments with them. So I think you structure the downloads in a way that you try and protect work product as much as possible, and hope that you get them comfortable in that way.
Yeah, I think, I saw some stuff when I was in the enforcement division that I thought, frankly, was kind of goofy, where people would come in and say, I'm not going to tell you what Bill said, but hypothetically, if you ask Bill these questions, here's the answers he would give. Now, if you want to stand up in front of Judge Rakoff and explain how that's not a privilege waiver, God bless you, okay? And I think people kind of tie themselves up in knots in a way to sort of put this veil of we're not waiving privilege when they effectively are. And so...
Just be ready, you're waiving privilege. You should just incorporate that into your plan.
There's always a balance. You're always balancing various harms.
Right, you've got to tell the committee, you've got to tell the company there's this balance and we're taking a risk here. There isn't a way that, other than disappointing everybody around us, to keeping this stuff safe. And instead we will do everything I can not to surprise you. Everything I can, I remember one forensic team was honest about search terms. And I said, well, we don't need to worry about that because with respect to these three key people, we read every single email. And in fact, the whole case turned on one email that said 0.01 question mark. And I said, what search term would have found that? But that was the penny they were looking for in the earnings case. And so that's one of the ways you can balance it also. Just work harder.
All right. Any other questions? All right. Thank you.
Thank you. Nice job.
All right, hey, thanks so much. Great panel, and Kaz, great job. We'll be back with the sleepy topic of cryptocurrency at 10 o'clock.